previous meeting minutes.
One second, Chair, Vice Chair Lucero. We don't actually, not yet, it looks like, have a
Oh, we
quorum.
don't. Okay, well then I'll hold on.
One, two. Yeah, we're gonna need just a few more members.
Oh,
We can
okay.
move those later in the meeting if we need.
Yes. Okay. Good deal. I saw
Yeah.
18, so I thought that we
Yeah, we
did,
have a few
but
members of the testifiers and such that are on the
yeah,
call. So
perfect. Nope,
yeah.
I appreciate that. So
Yeah,
we'll hold
thank you.
off on the adoption. But so then while we're waiting for a quorum, I'll pass it on to Abra if you could go over the agenda for us.
Yeah, thanks, Senator Lucero. I'm just going to share my screen here. Let me know, can you see that?
It is coming through.
Okay, great. So we're in the welcome and purpose section of the agenda right now, after which point we'll switch over to the public testimony and hear from a number of community members who are on the call. Next, we'll hear the first presentation, which is the National Perspectives on Dispute Resolution from Heather Morgan from the National Conference of State Legislatures, or NCSL. And there will be a question and answer period as part of agenda item 3. Next, we'll move to the presentations number 2, which will include Carly Kauf from Chestnut Cambronne and Chris Wilcox from Christensen Samsel, who will present other perspectives on dispute resolution. They're both attorneys and work on this issue. And then we'll have around 30 minutes for discussion among the task force or the working group, including continuing our work of drafting recommendations, picking up from last time, after which point we will adjourn and just announce that the next public listening session will be 2 weeks from yesterday, Thursday, December 19th, from 5:30 to 7:30 at the Ramsey County Library in Maplewood, and that our next work group meeting will be Friday, December 20th from 10 to 12. It's a hybrid meeting, so it'll be on Zoom and at the Capitol. And lastly, I'll just announce that for future meetings of the work group, there will be opportunities for public input. So if you're interested in testifying to the group, please email andrew.george@lcc.mn.gov no later than 3 days before the scheduled meeting. And please note that the testimony may be limited to ensure time for other items in the agenda. But of course, you could always submit a written version of your remarks that's longer in advance, and which staff will distribute to the working group members. Thank you.
Perfect. Thank you, Abra. And I should mention that Chair Bonner is running a few minutes behind. So as soon as she gets here, I'll be passing the gavel over to her. And while we're waiting for a quorum, I also just want to mention on the note of the listening sessions. So for those who are aware, we did have our first of 4 listening sessions last night. It was in Maple Grove. It was a standing room, so it was an incredible turnout. Thank you to the staff. Thank you for helping to organize that. Thank you for everybody who came out from the public to share their voices of their experiences and their concerns. And thank you to members of the work group for being there. And again, as we continue to receive that information and incorporate that into future recommendations. Looking forward to the next meeting, which was just mentioned, will be coming up in Maplewood. So the purpose.
Mr.
Go
Vice
ahead.
Chair, we now have a quorum, so if you'd like to pass the minutes from the last meeting, we can do that now.
Good deal. Okay, well, a quorum being present, then let's go to the first item of business, which is the adoption of minutes. Is there any discussion on the previous meeting minutes? And I am not seeing any hands. So seeing none, we'll take a vote. All those in favor of adoption of the meeting minutes, say aye.
Aye.
Aye. All those opposed, say nay. The ayes have it. The meeting minutes are adopted and the meeting minutes were for November 26th. The next item under item number 1 on the agenda, letter C, the purpose of this work group is to study the prevalence and impact of CICs and HOAs in Minnesota and how the existing laws regulating CICs and HOAs help homeowners and tenants access safe and affordable housing. Letter number D. As a friendly reminder of decorum, A reminder to our presenters and working group members, I completely understand that this is an incredibly passionate, long-standing issue for all of you, and I would kindly remind everyone to speak to each other with respect and keep a polite level of decorum. Please direct all comments through the chair rather than the person asking directly. The chair will call on your name and proceed and maintain discussion. Time limits, if the time expires or the agenda requires, the chair will ask that you wrap up your final comments so that we can move to the next testifier or agenda item. And please note that meeting agendas are structured to bring in speakers to provide information for the things that the work group is tasked with studying, with the expectation that each member will bring their valuable expertise to the discussions, which will guide work group decisions about what to bring forward to the legislature. And lastly, presenters and materials by speakers and testifiers are their own and not the opinion of the work group. And with that, let's move to public testimony, of which we have 3 people. So we're shifting to, again, public testimony. And a reminder, you have 3 minutes to speak. We ask that you adhere to the time limit to ensure everyone has a chance to speak. We will be timing the testimony and will indicate when you have 1 minute and 30 seconds remaining. And I'll leave that up to staff. If you could please make those notations if needed. And at the conclusion of your time, the alarm will sound and we politely ask that you wrap up your final remarks. So with that, let's call forward our first testifier, Mr. Hoy.
Good morning, everyone. How are you? Can you hear me?
Good morning. Yes.
Yeah, good morning. So thank you for the vice chair and the chair for making this opportunity available. Thank you. Just as an introduction, my name is Roger Hoy. I'm part of a small HOA and actually a small self-managed HOA located in Two Harbors, Minnesota. Silver Cliff Homeowners Association. My comments as you go through this and you look at these 515B statutes, I think it's important to make everyone aware, and I think it's very wise that you're doing this, make you aware of some dysfunction that exists in the current statutes that makes it almost impossible for a small self-managed community to be able to function properly. So let me just tell you a little bit about that. In the past, small meant under 25 units and with a budget under $75,000. When you're small like that, it's very, very hard. You don't have the critical mass to be able to go and hire an HOA management company. I think HOA management companies may have influenced some of this legislation because the way it's written now and it's currently structured, you can only comply if you have an HOA management company. Well, there are many of us throughout the state who are small that don't have that. And so the distinction that I'd like to make for you so that to illustrate this, there's a difference between governance, which requires a meeting and which requires compliance with the open meeting laws, and operation and maintenance. So since I only have just a few minutes, I just want to be clear. When you're in a small self-managed community, it's very important that you have a president, you have a secretary, a treasurer, but it's very important that they speak, that they talk, that they have discussion. How much weed killer did we use last year because it wasn't enough? The dandelions are, going crazy. Do we have batteries in the keypads? How much propane do we have? What's the price per cubic foot of that? People talk so we can operate and manage. Are we going to go trim up these trees or not? That sort of thing. We had a member who was very strict on it, read the statutes very strictly. Anytime 2 people get together, that's a meeting. Well, in order to comply in Minnesota with the open meeting statutes, you have to send out a notice. You have to have an agenda 30 days in advance. It has to be postmarked no more than 30 days in advance, no less than 10. And everyone has to be invited to that. With that encumbrance, when you're managing, when you're operating, doing management items, caretaking items, sundry items. Where does this go? Where are we going to store that? Should we look at a new sealer on the garage door? All these things. When people get together and have discussion, it's impossible to comply with the open meeting laws. And yet you'll have members who will say, well, you're not, you're in violation of this, and then have sent letters to other members who say you're in violation. And when you're knowingly in violation, then you have personal liability. Well, then people run from the board. So it creates just this huge dysfunction. And I don't think that's what was the original intent. And so I just want to say that it's important as you look at rewriting this that perhaps you may want to consider creating a distinction between sundry operation and maintenance and governance issues. So when there are governance issues, you're electing a new board, you're assembling a budget, creating a meeting for members. Our CC&Rs require 2 meetings a year, most do. People need to be
Hey,
notified.
Mr. Hoy, you have we have hit the 3-minute mark. So if you could kindly wrap up.
Yep. So people need to know there's a difference between a distinction between operation and maintenance and the open meeting side of it. I proposed legislation on this. It's on. I sent it to Abra, and so I thought you should know that that's there. Thank you for hearing my comments.
Thank you so much for sharing your remarks this morning with us. And next, we'll move on to Ms. Phillips.
Thank you, Vice Chair Lazaro. My name is Kathleen Phillips, and I like to be addressed as Kathleen. I live in a 60-unit single-level garden home community in Burnsville, Minnesota, which is handicapped accessible. I've served on the board for 12 years and president for the last 5. Next slide, please. So there are some frustrations from both homeowners and board members. Frustration with unresponsiveness of our property managers. In the 12 years, we've had nine property managers, 3 who were outstanding, 6 who were pretty horrendous. As you can imagine, there's little or no continuity in our association. Management has poor enforcement of rules. This results in property and tree and shrub damage that the remainder 59 homeowners end up paying to remediate. They don't follow the requirements of our governing documents, costing our homeowners hundreds of thousands of dollars. They allowed 1 rogue board member to sign contracts for work that was not approved by membership, and also to initiate very expensive road replacement contract with no competitive bids. Insurance concerns have been addressed by many previous testifiers, but we have an open claim that's been open for 3 years that prevents us from getting competitive insurance claims. This is due to the fact that Medicare is involved in an injury claim. We have the city of Burnsville, who denies homeowners and a homeowner association water shutoff service. This used to cost $75 per trip. Now they require we have to use an outside contractor at the cost of $750 a trip. That means if my water needs to be shut off for a repair reason, I have to have them come out for $750 to turn my water off and pay them $750 to turn the water on. I have been to city council, met with the deputy city director and head of public works. Their solution is, here's a copy of the ordinance. Have your attorney speak to our city attorney. Again, costing our homeowners many dollars. Next slide, please. Management company has spent our association dollars to pay for another association's electric bill for over 3 years, and also reimbursed other associations with our funds. When discovered, they refused to reimburse our homeowners, and a 2-year battle ensued with appeals to Dakota Electric, the Minnesota Attorney General, the Public Utility Commission, AARP Legal Services, and tracking down other associations who benefited from Winterwood Garden Homes paying their bills.
And pardon me, Ms. Phillips, you have about 30 seconds left.
Wow. I just want to touch on reserve studies from our recent homeowner leadership network. We saw that there were over $57 million in reserves, but when that broke down by housing units, there was less than $1,363 per housing unit available in reserve funds. This will be a crisis down the road, especially when you consider the city of Burnsville making us pay $1,500 to have water turned on and off for repairs. Next slide.
Well, with that, Ms. Phillips, so that's all the time we have now. But again, I'll just a friendly reminder that while you may not be able to finish verbally, the documentation, the slides that you're sending here will be made available to all members of the work group.
Okay,
so
and I also sent extensive written testimony with supporting documents for all of the things that I've spoke about. Thank you for your time.
No, thank you so much. Absolutely. Thank you so much. And with that, we'll bring forward Mr. Struck.
Thank you. Good morning. Thank you, Senator Lucero.
Good morning.
And Chair. My name is Larry Struck. I am president of the Wynwood Condominium Association, 7508 Cahill Road in Edina, Minnesota. Our association has 206 units along with amenities, many amenities. Today, I want to focus on just two issues that I believe are important for understanding the current situation of homeowner associations. One is the cost of insurance as it relates to affordability for owners, and the other is the volunteer basis of homeowner association government. As you probably know, there have been recent increases, some very dramatic, in the cost of homeowner property insurance. This is attributed to adverse weather events due to climate change. Many homeowner associations have been hit particularly hard by rising costs. Since our complex is large and over 50 years old, which is considered older for this area, we were dropped by our previous carrier who left the HOA market altogether. After a search for alternatives, we were placed in the secondary unregulated market, the excess and surplus market, which resulted in a 400% increase for our premiums. That cost had to be borne by owners through an increase in dues of about $250 per month. We have a diverse population in our association ranging from working families to retired seniors. The added cost has become a burden for many, some of whom will be forced to move. The point to emphasize here is that homeowner associations can be economical and enjoyable ways to own your own home. They can represent affordable home ownership at a time when single-family homes are out of reach for many. So I urge your working group to consider the impact of the insurance market on HOAs and be open to new or innovative remedies. And the second point I want to stress is that HOAs are overseen largely by volunteer boards of directors with help from professional management companies. In my experience with associations, these volunteers are usually, though not always, competent and well-meaning. They provide valuable service to owners when following their own governing documents and state statutes. There will naturally be disagreements and problems to solve, as in any governing organization. But I believe that overall, HOAs are beneficial and a great asset to the public. I commend and respect the work of this legislative group to find ways to ensure the continued health of common interest communities. Thank you.
Thank you so much, Mr. Struck, for your comments this morning. And again, thank you for all three, Mr. Hoy and Ms. Phillips. That ends the public testimony portion of our schedule. I will pass the gavel now to Chair Bonner.
Thank you, Vice Chair Lucero, and thank you for coming up in a pinch. I appreciate that help. I am here at the Capitol and just wanted to get started on the next portion. Thank you to all of our testifiers for today. And I do want to also take a point of privilege for a brief moment to say thank you to the work group members, to Vice Chair Lucero, who attended the listening session last night in Maple Grove. I think it was a resounding success. It was very well attended. And of course, thank you to Senator Warren Limmer, who also represents Maple Grove, for attending there as well. We were able to get some really wonderful insights, and we'll announce the next session again at the end. So thank you for that. With that, I think we'll move on to the next portion of our presentations for today. That is to get sort of the national perspective on how other states are dealing with some of the issues around addressing some of the the issues that come up with in dispute resolution. And so with that, we have with us today Ms. Heather Morton, who is from the National Council of State Legislators, to give us a little bit of background on that topic. Ms. Morton, do we have you handy?
I am here. Thank you.
All right. Thank you.
And let me just pull up my slides for you.
Miss Martin, I have them. Can you see them?
Oh, okay. Okay, perfect. There they are. Okay, thank you. Sorry.
Mhm.
I think everything is good there. All right. All right. Well, and good morning, and thank you, Madam Chair and members of the work group, for the invitation to return to speak before you today. For the record, my name is Heather Morton, and I cover financial services issues for the National Conference of State Legislatures. And I'm pleased to provide you with an overview of the dispute resolution and foreclosure of assessment lien laws for common ownership associations in the states. Next slide. And I know that I covered this in my earlier testimony a couple of weeks ago, but for those of you who are not familiar with NCSL, we are the country's most trusted bipartisan organization serving legislators and legislative staff for 50 years. Next slide. We serve all 50 states, territories, and commonwealths. NCSL is headquartered in Denver, Colorado, where we provide comprehensive and unbiased research on state policies and legislative institutions. We also have a small office in Washington, D.C., and their work focuses on ensuring that state legislatures have a strong, cohesive voice in the federal system. NCSL does not make policy recommendations, nor do we advocate certain positions to states. Instead, we promote policy innovation and facilitate communication amongst the states. We do this because we believe in the importance of the legislative institution and know that when states are strong, our nation is strong. Next slide. So I just wanted to quickly go over what I'm going to focus on today, and there's 3 areas. So ombudsman and resource offices, dispute resolution requirements, and then I'll give a quick high-level overview of state laws governing the foreclosure of assessment liens by common ownership associations. So now I'll get started with my first topic on the ombudsman and resource offices. Next slide. And recognizing that there can be and have been challenges within the self-governance structures of common interest communities, which can be of various sizes and experience levels, as we've heard from the public testimony a few moments ago. State legislators have acted to help provide a neutral party that can act as a liaison between the homeowners, the boards of directors, the association management companies, and others. These neutral liaisons are often referred to as ombudsmen, and they often have the responsibility to provide educational resources and trainings, and they can also help explain the rights, responsibilities, and processes for associations as specified in the state law. These offices, they may be authorized to receive complaints regarding potential violations of the state laws, the regulations, or the governing documents. They may have authority to facilitate or provide alternative dispute resolution services like mediation as requested. And they may help with monitoring or vote counting for association elections. And then they may also be required to prepare a report on the office's activities or complaints that are received by the office. And as I've marked in gold on the map, Delaware, Florida, Illinois, Nevada, and Virginia have enacted legislation that have created ombudsman offices. Marked in brown on the map, Colorado enacted legislation that created an HOA Information and Resource Center, but the difference is that this center does not assist with dispute resolution. While South Carolina, they required that their state Department of Consumer Affairs collect information regarding complaints about homeowners associations, but the department does not provide any educational or training resources and does not assist with any dispute resolution. Then finally, marked in red in the map, Georgia, Hawaii, Maryland, Massachusetts, Minnesota, New Jersey, and New York are the states that have had pending legislation that proposed creating ombudsman offices in the 2024 legislative session. Of these states with the legislation this year, Hawaii enacted legislation that requires that a study be performed on ombudsman offices. Require the State Department of Justice to receive and record data from all complaints concerning disputes between the association of what they call unit owners or lot owners and their members. And if enacted, the department would publish a report that would be similar to the South Carolina statute. Next slide, please. On this slide, I provided the website URLs for the states that have established offices in case you would like to review these and their individual information down the road. Next slide. So separate from the ombudsman offices that have the authority to provide dispute resolution powers, some states have specified some dispute resolution requirements within their common ownership statutes when issues arise between the association and the homeowner. So, for example, California requires an internal dispute resolution for common interest developments that applies to a dispute that's between the association and a member that involves their rights, duties, or liabilities. In the statute, the association must provide a fair, reasonable, and expeditious procedure when invoked in writing by either party to the dispute. And under the statute, an association may not file a civil action regarding that dispute in which the member has requested that dispute resolution unless the association has engaged in good faith in the internal dispute resolution procedures. Another example is that Florida requires that condominium bylaws must provide for an alternative dispute resolution where there's again a disagreement between two or more parties, and it triggers under specific circumstances, and those include when the authority of the board of directors to require any owner to take any action or maybe not take action involving that owner's unit, or the authority of the board to alter or add to a common area or element. That's one. And then the other is the failure of a governing body to, if they don't properly conduct elections, or if they don't give adequate notice of meetings or other actions, or if they don't properly conduct their meetings, or if they don't allow inspection of the association's books or records. And the Florida statute provides for arbitration or mediation, and within it, they set parameters for the proceedings, and that includes setting the qualifications for who can be the arbitrator, or mediator. For the mediation, they do have confidentiality provisions, and then they also set deadlines for the process as it moves through the dispute resolution. And Florida they do extend these provisions to encompass cooperatives and homeowners associations, but those are in separate statutes. Another example is Nevada. They provide that no civil actions may be commenced in court that's based upon a claim that relates to the interpretation, the application, or enforcement of any covenants, conditions, or restrictions that are applicable to residential property, or any bylaws, rules, or regulations that are adopted by an association, or the procedures that are used for increasing, decreasing, or imposing additional assessments upon residential property unless that civil action that they want to file has been submitted to mediation or arbitration first. And if a civil action is commenced in violation of these provisions, the court shall dismiss that civil action. So there is some enforcement power there. On the map, the states that are highlighted in aqua, and those are California, Florida, Hawaii, Indiana, Nevada, New Jersey, Oregon, Pennsylvania, and Wisconsin, they all have some type of mandatory alternative dispute resolution requirements specified in their statutes. Currently, in its statutes, North Carolina encourages that parties participate in a voluntary pre-litigation mediation. But there is legislation that's currently pending in the 2024 session that would amend the provision to allow, so it would change it to allow voluntary mediation that could happen anytime, but then it would also mandate specifically pre-litigation mediation. And then there was also legislation in New Hampshire that would have created a 9-member condominium dispute resolution board to hear and determine matters that involve the condominium owners and their complaints related to the failure by that condominium association to follow its declaration and bylaws, or the failure to follow proper voting procedures, and then other actions that are not in compliance with the condominium instruments or the Condominium Act. That legislation died in the process, so it is not going to move forward in the rest of the 2024 session. Next slide, please. Thank you. So shifting to the issue of whether common ownership associations have the authority and power to foreclose on an assessment lien that's filed against a homeowner. And I'm talking specifically about these assessment liens. So you can see from this map that most states do grant associations the ability to foreclose on those assessment liens. There are 3 states that allow for liens to be filed, but not foreclosed upon. And although I will say in one of them, in Louisiana, they call it a recording of a claim of privilege. And the other states, or I should, excuse me, the other jurisdictions are North Dakota and Puerto Rico. And then Arkansas, South Dakota, and Wyoming do not specify any foreclosure provisions in their respective common ownership statutes that are on the books now. In the states that do allow foreclosures on the assessment liens, the Common Ownership Association must provide, for the most part, must provide notice to the homeowner, except that the Guam, Iowa, Kansas, Oklahoma, South Carolina, Texas, and the U.S. Virgin Islands do not have specific provisions about the notice requirement in their statutes. And then in Delaware, Illinois, Mississippi, Montana, New Jersey, Ohio, and Oregon, they provide that the when the lien is recorded, that qualifies as the notification, and the associations do not have to give additional notification, any kind of additional notification, like sending letters or any kind of other notices. And then I did want to point out that what may be included in the scope of the Common Ownership Association's lien for those assessments, that varies from state to state. And some states limit the liens to only unpaid assessments for common expenses, while other states include the unpaid assessments plus any interest, late charges, and attorney's fees. And then finally, some states provide that the lien can include those unpaid assessments and any fines for violations of the declaration, the bylaws, rules, or regulations of the association, along with those late charges, attorney's fees, and costs. And, and as I wrap up this section, while I tried to hit the highlights on the authority to foreclose assessment liens, I want to emphasize that the foreclosure provisions tend to be very state specific. You have it, for example, on some of the notice requirements, like I said, it might be that they only have to file the lien and that qualifies, or it might be they can give 5 days notice, or some have 10 days and then some go up to 30 or even higher depending on what they've specified in statute. Next slide, please. So, as I'm winding up my presentation, I'll go quickly through these final slides. Of course, here are suggestions for different ways that you can access the NCSL resources. Next slide. And like last time, I would be remiss if I didn't make another quick shameless plug for the NCSL Legislative Summit in Boston, in case you're interested in attending. Next slide. And thank you finally, Madam Chair, for the opportunity to come back and provide this overview of the state laws that regarding the dispute resolution, the ombudsman offices, and the foreclosure provisions for assessment liens for the common ownership associations. And I'm happy to answer any questions and provide additional information if needed. And I've listed my contact information available on the slide, and these slides will be published online, published to the website if they have not been already. And thank you to Abra for handling my slides for me.
All right. Thank you, Ms. Martin. I appreciate that. And I think it's a really helpful to have something to sort of frame up our conversation when it comes to dispute resolution and some of those issues that we hear fairly commonly. And I think that was a fairly common theme through the listening session last evening as well. So it's really interesting to hear what other states are doing and how they're handling or tackling some of these really critical issues. So thank you for that excellent overview. Do we have any members that would like to ask a question? All right. Member Kimball.
Yes, thank you very much, Chair Bonner. I thank you for that informative presentation. That was really helpful. I'd like to better understand, you framed foreclosure of assessment liens varies from state to state. Based on the testimony that we've received, I think that Minnesota allows foreclosure for unpaid assessments, attorney's fees, costs, and fines. I'm wondering if you can verify if that's accurate.
I don't know if Ms. Morton could answer that for Minnesota statute, but do we have Ms. Davis on the line? Ms. Davis from research?
Yeah, Chair and members, I will pull up the statute and I can send that out to you. But that was in the presentation. I think it was from last week, from 2 weeks ago, the last meeting that we had, where there is a Minnesota statute related to those liens and the collection in foreclosures that allows attorneys' fees and other fees to be collected in the foreclosure. Yes. So I'll get that to you, and that'll have the details in it.
All right.
Thank you.
Thank you for that. We can go ahead and follow up with that information for the members. Any additional questions that are out there that folks have for Ms. Morton while we have her here?
Madam Chair, I have a question for her.
Member Daly?
Yes, thank you. I'm wondering, just for those states that do not include foreclosure in the statute, do you have any insight into what that looks like, what they do when there's unpaid assessments, dues? What happens if they don't foreclose?
Ms. Morton.
Thank you, Madam Chair. Thank you, Member Daly. Yes, so for those couples, those few states that don't give the authority to foreclose, they do allow that they can file the lien, and then that lien can continue until I'll say the delinquency, right, in terms of not paying the assessments or what's owed, until that is paid. Or there are a couple of provisions where they give an expiration date on when that lien may expire. If, like, for example, if it's after so many years, it might not be paid, but then I think I'm assuming that then the association can go back and maybe refile the lien, presuming, of course, that the homeowner might not have been still not be paying those dues, right? So they can go back and do that. But I want to say in Louisiana that it accelerates the lien. It can be accelerated, so it can add additional amounts to the lien itself, to that pending lien.
Okay. Thank you for that. All right. Any additional member questions that we have? Okay, I did want to ask you, Ms. Morton, on the question about dispute resolution. You had mentioned that there were a couple of different pathways there. And I'm sorry, right before you went into talking about Florida, there was another state that you had mentioned, and I missed which state that was.
Certainly. Let me go back, make
Sorry
sure I
about
get them,
that.
I get them in the right order. So I started with California.
Okay.
And they have they call it an internal dispute resolution. And they don't go into a lot of details about they don't give like a lot of details on the procedure, but they do say that it has to be fair, reasonable, and expeditious. Although I didn't note it in my remarks, but it was interesting to me that that the request for that dispute resolution has to come in writing, and either party can request it, but it depends on, so if the homeowner makes the request, then the association board, or the association has to come to the table and do that alternative dispute resolution. But on the flip side, if the association makes the request for the dispute resolution, the homeowner does have the choice whether to participate or not participate. And then, so that was California. And then I talked about Florida, and then Nevada.
All right. Thank you for that. I appreciate it. All right. And I may actually go back and review that part of the tape just to make sure I absorbed it all, because there was a lot of really good information there. Any other questions from members on dispute resolution, foreclosure, or any of the topics that we covered here today, or the ombudsman? All right. And seeing none, we will move on to the next portion of the schedule. I want to thank Ms. Morton once again from NCSL. They have been an invaluable research on many a bill here at the legislature. And so I am particularly grateful. As some of you may know, in full disclosure, I often work with Ms. Morton as part of the work group on AI, cybersecurity, and data privacy. And we have a group of legislators from across states that have been working on sort of the cutting edge of AI legislation to make sure that we can roll that out and get ahead of that critical issue in other states. So she is a bit of a jack of all trades, and we really appreciate you being here. Thank you, Ms. Morton.
Thank you so
All right.
much.
Yes, absolutely. And with that, we're going to move on to the next part of our agenda for today. We do have two subject matter experts coming in for today. And I do want to make sure that I frame up, of course, that, some folks have been asking about how we select these particular individuals to come in and speak as subject matter experts. And I just want to make sure that we understand that we've really tried to align the subject matter experts with the topic for each session. And we've tried to pull subject matter experts from a variety of sources with a really diverse set of backgrounds. And that could be from homeowners association, advocacy organizations, that could be from legal context, that could be from folks who represent community associations or property managers. It could be all kinds of folks from across the gamut, but we've really tried to find a wide variety of subject matter experts to speak to different components of the issues. And so many people have seen a very wide variety. But I also want to be sure to include in this the disclaimer that anyone coming before the committee, the views that they espouse are their own. That does not necessarily reflect the views of any individual or the work group as a whole. And it's important to note that, as well as any testimony that comes forward. So I just want to make sure that is clear for the general public and anyone listening in. And with that, we are going to go ahead and move on to our first presenter for today. We do have a subject matter expert to speak more to the sort of homeowner's perspective on dispute resolution and what it's like for them. We have an attorney, Chris Wilcox from Christensen Sample PLLC. And I will go ahead and introduce him here now to speak to us about that homeowner's perspective on dispute resolution. Mr. Wilcox, do we have you ready?
Thank you, Madam Chair. Can everyone hear me okay? As I'm an attorney with a law firm named Christensen Sample here in Minneapolis. We represent predominantly homeowners in the context of HOA disputes. But apart from that, I maintain a consumer law practice and a mortgage servicing practice and foreclosure defense as well. So a lot of what I might say today may go a little bit beyond the HOA context for purposes of providing background. So let me start by sort of setting the stage for my commentary with respect to the players involved. So ordinarily in the cases where we're representing homeowners, there is a property management company involved, and there is an attorney involved representing the association, either in connection with preliminary collection or foreclosure, if it comes to that. And so a lot of what I say in terms of my experience and any sort of recommendations by pointing to other areas of law that the committee might look at does not necessarily have in mind the small mom and pop association. And so the first thing to start with is this committee has already heard quite a bit about transparency with respect to voting, homeowner access to documents, things like that. And so I'm not going to spend a lot of time on that. I'm going to focus more on the issues of fines, fees, foreclosure, the incentives for property management companies related to those fines and fees, foreclosures, and then the sort of lack of accountability and lack of owner remedies that currently exist or don't exist under Minnesota law. And then finally, I want to point to the mortgage servicing context for where we might find ideas for how to address some of these existing shortcomings. So with respect to fines and fees, I'll give a few examples of how this has come up in our practice. And I certainly don't mean to malign any boards of directors or associations, but these are things that we've seen. So often when a consumer comes to us with a complaint about a dispute with their association, it's related, it may be related to a payment default. I don't want to focus on those today. Today, I'm more concerned with the imposition of fines or fees that follow a payment default. And so with respect to fees, for example, we've had instances where our client, was physically incapable of bringing her garbage can into her garage as required by the association's bylaws or rules and regulations due to a medical condition. And the property management company multiple times within the same month fines her for that. She attempts to dispute it. And there's no movement from the property management company or the board of directors on whether or not she's obligated to pay, despite a disability that prevented her from complying with the association's regulations. And so what happens next? Well, a foreclosure is commenced eventually, and in response, with someone like that, the risk of losing their home versus paying these small amount of fines that may be owed to the association, it's a no-brainer what a homeowner might do if they're unrepresented. And that brings up a point that hasn't been addressed yet today, and that is I know we saw a map of all the states that permit foreclosure of an association lien. But what's missing from that map is that Minnesota permits two types of foreclosure. One is a foreclosure by action, and one is a foreclosure by advertisement. And about half the states on the map that you saw only allow foreclosure by action, and the remainder may permit one or both advertisement or advertisement and action. And so with a foreclosure by action, the foreclosing party, whether it's a mortgagee or a homeowners association, has to commence a lawsuit where the homeowner is able to present defenses to the lawsuit. That's noticeably absent in the context of a foreclosure by advertisement. Certainly the homeowner can write to the association or the property management company, but ultimately, that it's not as though there's someone coming in to ultimately resolve the dispute before the homeowner is at risk of losing their home. And so in an instance like I mentioned, where our client had a legitimate and a very empathetic reason for any failure to comply with the association's regulations, I would expect most people would want that issue to be resolved before it came to an attempt to enforce an assessment lien and take this poor woman's home from her. So I think the distinction between foreclosure by action and foreclosure by advertisement is key in understanding this problem, especially as it relates to the fines and fees that might be imposed. Because again, most homeowners, if they're unrepresented, are going to pay it independently of whether or not it's correctly assessed or not. Or they're going to they're going to go to an attorney, and that attorney is ordinarily going to tell them, unless there's some sort of claim that would permit them to recover attorney's fees, that it's not going to be worth it to defend or bring a lawsuit to stop this foreclosure, because you'll ultimately pay more than you would save, in the amount that's disputed. And so again, I wanted to focus on the property management company context, because unlike the instance of a mortgage foreclosure, there's no pre-foreclosure protections other than those afforded by state law, which are sparse and few and far between. With mortgages, most of which are regulated under federal law, there are significant protections for consumers prior to foreclosure. We have what's called the Real Estate Settlement Procedures Act, which affords protections related to loss mitigation procedures to homeowners faced with foreclosure. And we have processes that permit mortgagors to request information from their mortgage servicer, and explicit statutory requirements that the servicer has to comply with in responding and providing the information sought. All of that is absent in the context of an association lien foreclosure. apart from what's provided by state law, which again is not nearly as robust in affording consumer protection. And so I think the key to looking forward and what approach might be taken to address some of these issues is an explicit error resolution procedure, like is present in Reg X, which implements the provisions of RESPA, requests for information governed by similar procedures. And the Reg X can be found at 12 CFR 1024 for those interested. There's also general policies related to reasonableness for mortgage servicers, early intervention requirements for foreclosure, and other loss mitigation procedures that would be helpful, I think, in guiding this working group moving forward. So with that, I will turn it over to any questions.
Chair Bonner, you're on mute.
Sorry about that. I thought I hit the button. Thank you, Mr. Wilcox, for that presentation to talk a little bit about particularly the foreclosure aspect, but also sort of covering that there appeared to be a number of lack of remedies to protect homeowners, particularly in the foreclosure space. And I know we did not go, Mr. Wilcox, into a great deal of information about sort of that earlier dispute resolution piece that comes sort of before that foreclosure action comes into place. I wonder if you have anything you can add or any background you can provide about some of that issue.
Certainly, and I think that's why I'm pointing to the mortgage servicing statutes, because those would permit an owner to send what's called a notice of error, basically to make their dispute known to the mortgagee in that circumstance. Something similar would work very well, I think, for the homeowners association context, with a duty imposed on the association to investigate the error being asserted and alert the homeowner as to whether or not they agree that there's an error and take timely action to correct it, or explain why they disagree with the homeowner. And ordinarily in the context of mortgage servicing dispute, you may have multiple follow-up communications to try and suss out the issue, or eventually there may be a lawsuit on either side of the dispute. But ultimately, the conversation happens before there's an attempt to take the homeowner's home under ordinary circumstances. And similarly, under those mortgage servicing statutes, there's requirements in terms of timing for when a foreclosure can commence from the time of default, that provide additional protection to the homeowner to send those requests for information if they need a copy of the declaration or a copy of some board resolution that authorizes the action. And so all those things, I think, let that happen before foreclosure, and certainly an ombudsman or a regulatory agency that's overseeing property management companies could weigh in on that dispute as well. Although that part isn't present in the mortgage servicing context, apart from the CFPB's oversight of mortgage servicers.
Right. Thank you. And then just a point of clarification. In one of the meetings last night, there was a testifier who came in and was talking about how she had a renter in her unit, and they assessed some sort of fee to her without her knowledge. She owns the property outright, and pays their dues on time every month. And apparently the fee was for $56. I'm sorry, I cannot recall for what. And she suddenly received something from the renter saying that they were being engaged in some sort of foreclosure proceeding. And when she went to inquire about it, they gave her a 2-day notice for when the foreclosure was to start. I think it was between the 16th and the 18th of December. So I'm curious to know, is there in Minnesota statute, or have you heard of other circumstances in which we are either failing to give notice, or we're not giving timely notice, or a window of notice?
Well, so I suspect I may know what the issue was in that circumstance. Under chapter 580, under 580.03, there is required service of a notice of foreclosure on the person in possession of the premises. Now there may be other issues about whether under case law the owner of the property must also be served with that with the notice of foreclosure, and certainly it would seem to me it would be a good idea to impose that requirement. But my guess is maybe that's what the issue was. Ordinarily, that service would need to occur at least 4 weeks in advance of the sale, and if that didn't happen, the sale couldn't proceed. Or if the foreclosing attorney did proceed with the sale, the sale would be void by virtue of the failure to comply with the notice and service requirement.
Okay. Thank you for that clarification. I appreciate it. Member Daly, we have a question.
Yeah, thank you, Chair Bonner. I'm wondering, I don't know, Chris, if this is a question for you or for the next presenter, but I'm curious about what the contracts between the homeowners associations and the property management companies are like, and do they in fact sometimes incentivize property management companies to put on fines or to go after money? Do they get, I'm sort of just wondering what the relationship is like, and could that be part of the problem?
Yeah, so I will admit I'm privy to very few contracts between associations and property management companies, largely because has been reluctance to produce those in discovery in litigation. But so those provisions incentivizing the imposition of fees may be there in some contracts. I can't speak to that. But the other thing that is my understanding is ordinarily those contracts also contain indemnification provisions that indemnify the property management company in the event that there's an issue that arises based on an act taken by the property management company in the course of their agency relationship. And so if there were an issue with the imposition of the fees, my expectation is that it wouldn't be the property management company that would have skin in the game on any claim that might be brought as a result.
Thank you for that. And then we have one more comment, and then we're going to move on to the next presenter that has a little bit more of a perspective of the homeowners associations. Member Howard.
Thank you, Chair Bonner. Mr. Wilcox, I just was trying to understand your perspective when you were talking about the RESPA requirements. I mean, aren't all attorneys that collect for associations governed under the Fair Debt Collection Practices Act? So they have to send the standard Reg Z notice, which gives the owner an opportunity to dispute and request validation of the debt and all of those sorts of things before it ever gets to foreclosure. So what is your suggestion that would be added to that by adding additional regulation similar to mortgage servicers?
I'm sorry, did you say the Reg F notice? Is that
Reg
what you're
Z.
referring to? Okay. Well, so again, we have the FDCPA as it's drafted, and we have the decision from the Supreme Court in Abdusky that limits the application of the FDCPA significantly as it concerns an attorney solely undertaking a non-judicial foreclosure. And so is there some protection for a homeowner afforded by the FDCPA? Yes, there is. But that protection is also going to be subject to a bona fide error defense for the attorney or whoever else is a debt collector under the FDCPA. And the number of actions it's going to apply to are going to be limited compared to those that are actions that we wouldn't otherwise permit under mortgage servicing regulations.
If I'm understanding you, Mr. Wilcox, and just to try to paraphrase for the folks who are non-lawyers on our membership, what you're saying is that the Fair Debt Collection Act, or the FDPCA, I think I'm getting that right, does have some protections for homeowners, but those protections are somewhat limited, and that if you were to look at something like RESPA, or the Real Estate Procedures Act, that might have additional homeowner protections that are afforded in similar situations, such as a mortgage foreclosure.
Correct. So just to by way of additional background, and I'm sure Ms. Koff will have more to say about this. But the FDCPA is limited in terms of the parties it applies to, and so a claim couldn't be brought against an association themselves under the FDCPA. And additionally, there's language about what sort of entity is a debt collector under the FDCPA. And there's something called the limited purpose definition under 1692A, A6, if I remember correctly, that says that if all the attorney or debt collector is doing is enforcing a security interest, then they're only subject to 1692 F6 under the Act. And so if we're just talking about the notice of foreclosure that's required under state law, and then the conduct in the non-judicial foreclosure proceeding, most of that is going to be outside of the ambit of the FDCPA's protections because of that limited purpose definition.
Thank you. I want to be careful because we're getting into some territory where there's a lot of lawyers speak, and I'm not sure that the members are going to understand all of that. I will give Ms. Howard a last moment to ask a follow-up question, but I do want to get us to move on to the next section because we do have an attorney that represents associations coming in to give their perspective, and I want to be careful about getting too deep in the weeds on sort of that very specific attorney language that may not be readily understood by the public or by other members of the committee. Ms. Howard.
Yes, thank you, Madam Chair. I just a quick follow-up on that, where you indicated that it doesn't apply to the limited purpose. Has it been your experience that an association or their attorney or debt collector would only seek to foreclose the property and not try to collect the debt before it ever got to foreclosure? And just, it doesn't seem like that would ever apply to this situation. Or they would not be covered under the FDCPA.
Certainly, I would say my experience is that ordinarily the attorney representing the association is dunning the homeowner, so sending a letter to attempt to collect the debt in advance of the foreclosure. Yes.
All right. Thank you for that. And with that, we are going to move on to the next presenter on the list today. We do have Miss Kauf, who is an attorney with Chestnut Cambrone, if I'm saying that properly, to speak to the group. Ms. Kauf.
Thank you, Madam Chair. Like you said, my name is Carly Kauf. I'm an attorney and partner over at Chestnut Cambrone. We're in the North Loop. And pretty much all of the attorney work that I do is in this HOA space. I represent homeowners associations, but then we also represent owners in a similar way that Mr. Wilcox does. Just really anyone who has a real estate issue that involves HOAs is sort of where my expertise lies. And so I really just wanted to come and provide, you know, to the extent I can, I'm a fallible human, but an unbiased background and a framework and perspective of sort of how HOAs are conducting their business in Minnesota, and you know, some things that we could do to improve these protections for consumers and improve the ability of associations to conduct their business. And so, you know, one thing that I think is really, really important to point out is that nearly all new residential housing that is being built in Minnesota are being put in HOAs. And Madam Chair, if you grant me permission, I'd love to follow up with better, you know, a citation for that. So I'm not just, you know, saying that out of thin air. But when we talk about it in industry meetings, when I talk about it with other attorneys and contractors, builders in this space, the numbers we hear are upwards of 85% of new residential builds in Minnesota are homeowners associations. And that makes a lot of sense for municipalities to avoid municipal costs or to pass those along to the association costs and things like that. But what it does is it creates a need to be really, really purposeful about this structure so that we make sure that people are being treated fairly. And so, you know, one really important thing that I want to put in perspective is that absolutely we want to protect the consumer owner. But remember that all of those owners at that association are consumers. All of those owners at the association are entitled to be protected for their home and for the value of their home. And it's important to know that when, you know, I always think of the association example as 100 units because the math is easy, right? So if Carly lives in an association and she doesn't pay her assessments and the association has no way to enforce that lien against her unit, then just by definition, those other 99 units are going to have to absorb those costs. And when it was really nice to hear those homeowners today testifying, because I think that really gives us a good perspective, which is we have to figure out the way to balance those things. We have to figure out a way to both protect owners from, say, unlawful actors or people who aren't doing it the right way, or all of those things that we know are always a problem in just general business, right? We always have to protect. But also, we cannot do so at the expense of the association itself, because what that's going to have the actual result of doing is hurting consumers in the end. And so what's hard for these discussions is that sometimes the owners who are the most disgruntled or are the most unwilling to follow the covenants at their association are the ones that we hear from the most. And so I want to provide a perspective to say that, as our testifiers today said, nearly all of the board members that we as attorneys work with are doing their very best to act under their fiduciary duty on behalf of their association members. Remember, these are neighbors, right? These are communities. These are people that live down our street. Generally, what I find, and when I say generally, I mean more than 90% of HOA boards are working very hard in a volunteer unpaid capacity to act on behalf of their owners. And so when we talk about updating the Minnesota Common Interest Ownership Act, which I will annoyingly call MCIWA because I can't stop that from coming out of my mouth. When we update that provision, I think absolutely we can talk about making, minimum dates to provide notice, or to make sure that those provisions of the FDCPA apply in this context. As Ms. Howard said, in my experience, I do these collections for associations. I know Ms. Howard does too. We always send out a done notice. We always comply with the FDCPA because it's such an important right. Of course, what we're talking about here are not the ones that are coming to Chestnut and Cambronne and to Helmuth and Johnson to get their collections completed, right? We want to make sure that everyone's complying, even, let's say, if it's an association collector or somebody else who isn't otherwise bound by these other statutes. Those types of things, in my opinion, are fairly easy to write in. But what we want to also do is remember the things that we already have in place. So when we talk about dispute resolution, MCIWA already requires that if Carly gets fined for not bringing in her garbage cans, that I have the right to demand a hearing in front of the association, that they have to consider it, and that if they change their mind, they can't charge me attorney's fees and costs for saying, hey, Carly, gosh, it looks like you requested a reasonable accommodation because you had a broken leg and couldn't bring in your garbage can. We're not going to fine you. And, that is already the process that associations follow. So any associations that are already bound by MCIWA, which is all condominiums, all townhomes that were built after 1994 and more, already have to do that. And so I agree we could make it more robust, but what that's all going to come back to, and what I'm going to keep going back to, is education and understanding from our owners and our communities. The things we're talking about here, we already have, right? Associations already have the requirement to notify their debtors before they foreclose. Associations already have the requirement to hold hearings and not pass on fines. I wanted to make an important comment. No, I will say I absolutely do not think that management company contracts include incentives for property managers to fine unlawfully or act in a way that is contrary to the best interests of the association. Absolutely. I draft those contracts. I work with associations on those contracts. I think doing so in that manner would be unethical. And I know that other attorneys in this context, we've talked about it before. If there are associations doing that, then that's, I think, something we can already address under Unfair Business Practices Acts that we have in Minnesota. Again, there are always going to be outliers. There are always going to be people or associations or groups or anyone acting outside the bounds of the law. But here we already have these tools in place that if we make people understand them and be able to use them better, then I think many of the problems we're discussing are already solved. And so, what I wanted to highlight is that associations are already notoriously tight with their funds. Sometimes we have to, when it's a very serious legal issue, boards are very reticent to work with attorneys because they don't want to increase costs for their owners. They don't want to levy them against individual units if they can avoid it. Again, there's already reasonableness built into this statute. We all read the boards under 317A, the Nonprofit Act, under MCIWA 515B. These association members already are required to act reasonably. So, for example, the example that Mr. Wilcox gave about the garbage can, I'm not saying that doesn't happen, but there is already a structure in place to say that is an unreasonable reaction to the way you're enforcing that, and she shouldn't have to pay that fine. Another thing that I think is really important is that sometimes we skip over the middle part of they issued the fine and then all of a sudden it was at foreclosure and at sheriff's sale. That almost certainly wasn't the case. And if it was the case, then it was done unlawfully, and that sheriff's sale, like Mr. Wilcox said, should be held to be void. If an owner doesn't get the proper notice, if that notice is provided to the wrong party, if they don't do the things that the law already provides, absolutely those circumstances should be handled in a way that all non-compliant things should be handled. But what I want to be super careful about is sort of not tying the hands of the association in a way that makes it impossible for it to conduct his business. Because in a land where we know it's going to be increasing and increasing over the years, it would make them impossible to run. And the outcome that we see is significant increase of assessments and the costs of the association, costs of overhead, costs of actual goods and services. And then, as one of the testifiers talked about, the cost of association insurance is at a crisis level. It is absolutely like I've never seen before. And associations, even ones that haven't had to go to the secondary market, are seeing increases of insurance costs of 100, 200%. And so where we already know these costs are going to increase, the effect of limiting the association's ability to collect and enforce its covenants and its liens, all that's going to do is pass those costs on to the other owners. So, what I really want to leave here with, and I'll tell you, I'm a member of this CAI, which is the Community Association Institute, and we had our gala last night. And so there was a lot of industry professionals in the room, including homeowners and board members and everyone. And the feeling that I got is really a sense of wanting to work together. Like we're all on the same team. You know what I mean? Lawyers who work in this area, property managers who work in this area, I think we all agree that improving transparency and improving training, education, knowledge, and understanding with our owners, with our property managers, that's going to be where the improvements are going to come. If people fully understand the covenants that they're agreeing to, if people fully understand, if I do this, then this is going to be what happens, then that feels a lot more fair and a lot more ethical to me than some type of nefarious underground action like Mr. Wilcox was talking about. I don't think that's controversial. You know what I mean? I don't think it's controversial to say that owners should be given notice prior to foreclosing on their units. So I would love to take any questions, Madam Chair, and I would be happy to, provide any further information that I can.
Thank you, Councilmember or Councilman Kauf. Member Daly, you have a question?
Yes, thank you, Chair. Sorry to be hogging the questions here.
Nope, you're all right.
So I guess when I asked about, are property management companies incentivized, I didn't really mean explicitly incentivized. I meant more like, to be honest, I'm a homeowner advocate. I work for legal aid, so that's my perspective. Sure. But, we see so many situations where folks it's a pretty small debt. It's either, didn't pay your dues for a few months or some fines that maybe the person doesn't think they should have to pay.
Sure.
And I certainly have seen numerous times people getting fined without really having an opportunity to be heard. But one of the things you said, so 2 points. One of the things you said was that there's already a mechanism sort of to deal with that, if it's unreasonable. But I think part of the problem is there really isn't a mechanism to deal with that. Because if somebody says, hey, I was in the hospital, you fined me for not bringing my garbage can in, that seems unreasonable. And the board says, no, sorry, we think that's reasonable. We have to apply the rules to everybody equally. We can't just say, you're an exception. the only mechanism to deal with that is for the homeowner to hire an attorney and go to court and fight them. That is literally the only way to not pay that and also not lose your home. So, yeah. So, and the other thing I just wanted to ask was sort of like, I feel like the statute in some way incentivizes foreclosures, because once you owe this money and now you have these large attorney bills, it's a disincentive for the association to work out a payment plan, because maybe they'll see that money over time, maybe they won't. If they foreclose, they're going to get all that money back, because that's the way the law works. And so your lawyer bills can be, no shade on private attorneys, because I work for legal aid, but I mean,
No.
lawyers can be charging these associations $600 an hour. Somebody asks a question, the lawyers write them a letter, they get a bill for $600, $1,200. Like that, just, if we're talking about trying to cut costs, there seems to be something wrong there to me. So just wondering what your thoughts are on any of those points.
Madam Chair, is it?
Councilman Kauf.
Okay. I'm glad you brought that up, because one important aspect that I want to bring up is that is not my experience at all in terms of payment plans. My experience with association boards is that they go out of their way to allow for payment plans, because when there's enough equity in the home and things like that, they can get their money, but not all that much faster. And what my experience is especially when it's a smaller amount, we just want to bring them current so we don't have to keep paying this. Another thing I think is really important is that last year the legislature changed the foreclosure statute to specifically not permit a sheriff sale to include a requirement to pay those attorneys' fees and costs. And so I believe the legislature has already addressed what could be perceived as a concern of, I can't save my home because my $56 assessment now costs me $1,250 because of attorney's fees and costs. Under CICHOA currently, you wouldn't have to pay those attorney's fees and costs to save your unit, which again, my understanding from associations has been a fairly positive change, which is to say we get to see what the actual issues are and be more purposeful about levying those fines and assessments. But I think it's also really important to say that in some instances, it's true. You know what I mean? In some instances, boards don't act in a reasonable way, and owners need to be able to have a way to address those issues. In the circumstance that you, Ms. Daly, recommend or talked about, in theory, right, they wouldn't have to get an attorney. They could email their property manager and say, hey, this is not an issue. Here's why I did the thing. But you're absolutely right. If the arbiter of what is reasonable is the board itself, and that is the way that it is written under the statute. That's the way that it's written in all common interest community statutes in the United States, because that is how it runs under the board of directors. And so an outside ombudsperson, I think, is something we've talked about at CAI a lot, and I think we're very open to. You know what I mean? Getting the right person in that role, of course, making sure that it's cost effective is always the important thing. I'd love to see more information about how much gets submitted to them, how much resolution they're providing. If I talk to my friends at the AG's office, I know that this isn't necessarily something they have time to prioritize. So those type of solutions, in my mind, would be beneficial.
And just as a point of clarification, Counselor, you suggested that under the current changes to the foreclosure law, that they would not be subject to having to pay the attorney fees and so forth. So in the situation that we gave of the woman who came to the listening session last night and there was a $56 fine. She ended up paying, I think it was $2,500 and some change, in addition to the fine. And then on top of that, I think she had to pay another $255 to the lawyers for some sort of assessment after that. So are you suggesting that if she had waited and gone into the foreclosure proceeding and then it was deemed unreasonable, then she would have only had to pay the $56 and not had to pay the attorney fees?
No, I want to be really clear. I apologize if I misspoke. It's not that she would never have to pay them. It's that in order to keep her home, the only amount that she would have to, in order to save her home from going to sheriff's sale, would be the actual debt or assessment owed. There would still be a lien on her unit and the possibility of a personal judgment against her for those other costs and fees. But the change to the statute last year was, I guess in my interpretation, was to make sure that people didn't lose their homes in these type of circumstances. And so she would pay the $56, the sheriff's sale would be canceled, then they would still owe those attorney's fees and costs, assuming that they were legally assigned. You know what I mean? But Ms. Daly's correct that there's not a, council of arbiters that decide in Minnesota, you know what I mean? And to bring these contested issues to, and I know that that's the function that we're thinking an ombudsperson could hold, right? Is sort of this neutral party to bring these really tough ones to say, hey, I don't think they're doing this right. And I'm not getting what I need from my manager. And I don't feel like anybody's doing what they're supposed to do. And I think it's illegal. That's what an ombudsperson could, manage.
And just one other clarifying question. So, if let's say they pay the $56, so that cancels this sheriff's sale under the current law. That means that they still owe, let's say, I'll just round it off. Let's just say $2,000, okay, in attorney fees. So does that mean that the clock then stops? But because the situation in which I was understanding is that on top of paying that, it did not stop the clock and that those fees continued to accrue. To have a conversation with the attorneys. And I've heard numerous examples of that. And so it feels a little bit like a Chinese finger trap, right? The harder you try to get out, the deeper you get in, and the harder it is for the homeowner to actually dig their way out. And I guess I'm curious what your thought is on A, if that is the case, and two, what is the solution to that? Because adding up more fees on top of, say, someone who's low income or a senior who does not have those funds isn't necessarily going to get the debt paid. It's not going to resolve the issue. And in fact, it gets further and further down the road. And it could really be a detriment to folks who maybe have disabilities, who are seniors or low income. And I'm really trying to understand what the solution is there, and if you have thoughts or recommendations on what that might be.
Yeah, and I think you've really kind of hit the nail on the head of the balance that we have to be able to find, which is you're right that those fees would remain a lien on the unit. And to the extent that interest or fines were permissible under the contract documents of the association and under CICHOA, they would continue to accrue interest or fines under that are permitted. What's hard here, of course, is that associations should not be or I suppose owners should not be incurring legal fees and costs unless their actions necessitate the association to engage legal services, right? And so the problem, of course, is that the only alternative to assessing individual fees and costs against the owner who's causing the costs to be incurred is to have the association incur them themselves, meaning the rest of the 99 units incur that. And so when I talk to associations about whether to assess attorneys' fees and costs, we talk a lot about that reasonableness, which is, give a lot of notice that, hey, the reason that, here's what the issue is, here's our response to the issue. What we see is that the people who have their attorney's fees and costs assessed are ones who get the answer to the issue and then don't agree with the issue and then want, or the response, and then want to change my mind or somebody else's mind or whatever. At some point, the association both has a legal obligation to respond to that owner and has a fiduciary obligation to its owner to assess costs individually when they only affect individual owners. That is not meant to be a judgment against that owner for seeking help. And I agree with you that in some circumstances, it means that there's a disincentive for me as an owner to access help if I know they're going to get a lawyer, because it's going to cost me. And I think an ombudsperson is one of the ways we can fix that, to know that there's some type of, counsel or somebody to bring this to, or because what we find is people submit them to the AG, right? They submit the consumer complaints to the Attorney General, and again, they don't have the resources or any to sort of respond. But also what we find a lot is these circumstances come up with owners who are consistently not following the laws and the provisions. And so we need that mechanism otherwise they won't comply. Which is a lot of words to say, I don't have a perfect, I don't have a perfect way to fix it. What I think is really important is to make sure that we're not benefiting the individual at the expense of the group.
Okay. All right. I do want to point out that we are at 11:36. I do have 5 members on here. We're going to get those questions, but I do want to make sure that we try to keep the questions and answers as tight as possible, so we have a little bit of time left at the end to talk about recommendations. Member Cole, if you could keep it concise.
Okay, thank you, Chair Bonner. For one, I want to say I am tired of hearing about how the board is just volunteers. It's not about how much they are paid. It's about what their role is supposed to be. And the reasonableness of going to the same people who are hell-bent on making your life miserable to begin with doesn't make any sense. So yes, I do appreciate the support behind the ombudsman, because sometimes there really does need to be a third-party intervention and some third-party piece in this. My question is, about the comment you said, don't tie the hands of the board. Well, what is the role of the board? The CCRs don't talk about how you are supposed to have a budget that makes sense. My CCRs say that I can't have a meeting of religious instruction in my unit, but they don't talk about having business practices that make sense for the board, or if the board does decide, well, in our case, the board has been appointed by the management company, and I'm not allowed to talk to the board without going through the management company. I got that several lawyer letters telling me I'm not allowed to talk to. So that's an expense. I'm not doing anything wrong, but that's an expense that my dues are paying to have this lawyer send this letter to me to tell me I can't talk to the board. So what exactly is the role of the board to begin with?
All right, thank you. I just wanted to clarify what the question was.
Yep.
And I think knowing that is important. So for your association, though, that role is going to be specifically outlined in your bylaws, probably also mentioned in the articles of incorporation, and importantly, also in 317A. So Minnesota Statute 317A is what outlines all nonprofit boards requirements in Minnesota. Those ones that are going to be specific to common interest communities are going to be expanded upon in 515B.
My management company wrote our bylaws specifically for the benefit of the management company. So, but, and also in those statutes, it says that the board doesn't have to follow the bylaws if they don't want to.
No.
Yeah. All right. Thank you, Member Cole, for the question. I do want to go to the next person because I know we have quite a few hands up. Member Taylor.
Yes, thank you, Chair Bonner. I have a few comments and then a question. I would say in response to some of the, things that we've heard today, I would say one of the things I want to say is that similar to boards are doing their best, homeowners are usually doing their best to
Absolutely.
comply with the things that are happening, the requirements made of them, the extensive requirements made of them, and in these situations that are much more like landlord tenant dynamics than homeowner dynamics. And so the power imbalance really, really needs to be put into focus here when we're talking about boards versus homeowners, because really the only difference is you're building equity and you get to decorate your house. But other than that, you are in the same power imbalance as a landlord in a tenant situation. I think if HOAs were operated more like co-ops with collective governance requirements, we actually wouldn't have as many issues with running the organizations. There may be requirements in place for boards right now. They don't work. That is why we're here right now. And so there's also no strong enforcement mechanisms on those requirements for board members. We've got things in laws that say, if the board doesn't do these things that are required, that doesn't mean that homeowners don't have to follow it. Okay, well, then what's the point of the requirements then? So I want to also uplift the solution of state-funded third parties like the Ombudsman, contracts with Conflict Resolution Center or the Attorney General. One thing that I do know is true is that CAI lobbied against the Attorney General having a division set up in Bill 311 in North Carolina. And so I would like to see CAI stop lobbying against things like this that are beneficial to both homeowners and board members, where there can be third-party dispute resolution where there isn't a profit motive involved. I know CII also lobbied against foreclosures for less than $2,500 in North Carolina. I think that these are very reasonable, often bipartisan laws that are not being able to move forward because of the strong lobbying with CII against these. So I want to just uplift that while we're hearing that CII wants reasonable things, there are very reasonable laws being proposed that are often getting shut down and pared down because of CII lobbying.
Ms. Taylor, I just want to check in. And do you have a question in there?
Yeah. Well, I also do we have discussion period during this section?
We are, but we have 4 other members on the list, and we're a little short on time. So I just want to make sure we get to the questions while we have the experts here.
Yeah. So the question I have is the same one I had for somebody from last week, which is, we have requirements that are strong and penalties that are strong for homeowners that do not follow, the rules they're signing up for. I don't think education is usually the issue. So my question is, what are the reasonable and equitable consequences for board members who do the same? It cannot be foreclosure on one end or you get kicked off the board on the other, because the equitable consequence for not following the contract on a homeowner side would be you don't get voting power or something like that. It is not you lose your home. So I would like to know, what do we think is a reasonable consequence for board members that aren't following their parts of the contract or the bylaws? And is that up to an equal foreclosure as well?
Counselor?
Sure. I share your concerns about equity and making sure that that issues at HOAs are handled in a non-discriminatory and equal way across all owners. I have to disagree with you that there should be that there should be punishments for board members acting within the covenants of their governing documents to enforce the costs and fees of their association. That does not mean that boards should be able to do things that are illegal or unethical. But for example, if Carly doesn't pay her assessment liens and it's been 6 months and they've given her notice that they're going to have to foreclose, the board isn't at fault or doing anything wrong by continuing to foreclose against her, because that is the mechanism that we have for these voluntarily opted in owners who
Right. To
chose
clarify,
to
I
live in an
didn't
HOA.
ask for, to clarify, I'm not asking for when they are following procedure.
Okay.
I'm asking for when they are not following procedure. What
Member
should the
Taylor,
consequences be?
just a clarification. Please make sure that all questions and comments go through the chair. And we just want to do that to make sure that we maintain decorum and that we're all being respectful. I'm sorry, and I want to let the counselor go ahead and answer.
Tell me again when they're bad actors, what do we do? They get voted off is the democratic process that fixes it. But if they're acting outside of the law, if they're then under 317A, there are remedies to hold that person accountable. Of course, like all boards for nonprofits, unless there's an exceptions, these are volunteer unpaid, and thus, like all agents, would be indemnified by the association, same as their property manager, same as anyone else. This is not specific to HOAs. This is an agency law for all actors on behalf of others.
Thank you for that, counselor. I am going to move to the next member to make sure that we keep going. Member Murray.
I guess, how do we address, like, I've heard this persistently, this pattern, and the core of my question is, how do you suggest we address that either labor or unpaid labor or unpaid labor and the exposure to the secondary trauma of these stories and making these decisions is leading to bad outcomes? You get jaded, you say, oh, heck with it. And it gets a lot easier to pull the trigger the second time, the third time, and you don't flinch. I was off on a call to the Ombudsman of Human Services, where they are not aware of a new provision prohibiting lead agencies from making up their own rules. And they were like, oh, well, I'll look into it. And that, like, the unpaid work, you get jaded as a volunteer. And that's, I believe, what is leading to a lot of these decisions through empathy burnout. Because you just can't care. It's not a thing of they don't care. They cannot. Like, there's not enough left of them. So how do we address this? How do we create an enforcement mechanism to remedy the issues Member Taylor raised? And how do we not replicate a failed ombudsman office or a failed enforcement office at the Attorney General? Because it's going to happen if we don't do it. Thank you,
I'm
Madam
not
Chair.
sure. That's might be a little tough for the counselor to answer, but I'll let you.
Only to say that I do think an ombudsperson is I share your concerns about making sure that this isn't a sticker fix and doesn't actually do something, or that we're spending more to fix a problem than it would cost to do in another way. And so, I mean, for me, the way that we do that is by having these types of transparent conversations in which we're allowed to say hard things that might make people's feelings hurt and also that need to be fixed. Because I think you're right. What we see is board members simply unable to carry that burden any further. Of course, it's disingenuous for me to say rely on your professionals to help you, because of course I'm a for-profit attorney, and I don't think that that's I think that's important to note. I get that. And the times we see the best outcomes are when the boards are able to lean on professionals for help because it's too big of a job otherwise.
All right, thank you. I'm going to move to the next question again. Please try to keep your questions succinct. I'm actually going to go I'm going to go actually to Ms. Moritz, but first, because I think she may have some of the perspective of the AG's office to add.
Yes, thank you so much, Chair. So I've heard multiple comments about the Attorney General's office's workload and ability to weigh in on these cases, and I would love to offer some clarification from the Attorney General's office. I am the AGO designee on this task force. So I will say, first off, we also support ombudsman and government regulation of HOAs. I would recharacterize our involvement in this work. I will just echo, somebody else mentioned this, the Attorney General's office has no specific enforcement authority in statute over homeowners associations. And often the reason that when we do receive complaints from residents of Minnesota or Minnesota residents, the reason that we do not get involved is not because we lack the resources or capacity or interest. It's because if the Attorney General's office sends a letter to an HOA, the homeowner will still be charged that HOA attorney's fee that they are billed for, even if they have their own private attorney or send their own letter. So often when a homeowner comes to us concerned, we advise them that if the Attorney General's office sends this letter to your HOA on your behalf, you are going to be billed for the attorney's time that your HOA spends responding to it, the same as if they sought private representation on their own. Coming to the Attorney General's office does not absolve them of that really large bill that they're going to receive. So often we make them aware of that. I don't know that all private attorneys do. I presume most do. But we will make a homeowner aware that in order to get a response to this letter, you'll be charged that fee. And we often find that fee outweighs their desire to have this letter sent. So it's not simply that we just don't have the time to deal with these. It's just that we have no specific enforcement authority or ability to get them out of that often very, very burdensome lawyer fee.
Thank you for that insight. I appreciate that. I do have two additional questions that I want to get to. Member Kimball.
Thank you very much, Chair Boehner. Ms. Kopp, some of your argument seems to be about framing that HOAs can't function if there's no remedy for collections. And I certainly understand that argument for common areas that require maintenance. Help me understand how that argument applies to fines for things like not bringing in garbage or having a garden like we heard about yesterday from the Heritage Park HOA. Why should an HOA be able to fine and foreclose in those cases?
Well, because that's the fundamental purpose of a homeowners association, is to regulate the exterior appearance and the behaviors of the association members. This is a really good example of sort of what I see as a fundamental criticism of homeowners associations, which I think is very valid. So please don't hear that as a judgment. But one of the sort of catchphrases that I use with associations is that you can't have covenants that you don't enforce. And so the association board, under their governing documents, have a legal obligation to enforce those rules. Now, of course, they can change those rules. So if, gosh, it sure seems like this garbage can rule isn't serving our association properly or whatever, they can change those rules. But as long as they follow the legal process to do so. But those exterior appearance rules and all those things are sort of the fundamental purpose of an HOA. And so, when a person, the bargained for exchange that a person who buys at an HOA, part of that is that the people there are going to have to follow these rules. So I know what I'm going to expect. Whether or not that's something I value as a homeowner is, of course, up for debate. But when we opt into living in an HOA, we've chosen to live within those covenants.
Thank you. And obviously, I will say, just to be clear, we are running late. We have only about 5 minutes left technically, and we have not gotten to talk through any potential recommendations out of this session. As we imagine, dispute resolution is a difficult topic. And of course, we also see that is no exception in our discussion here today. I do have one member left on the list, and then we're going to close out this section. Member Hanson.
Thank you, Madam Chair. I'll try to make my question brief. It's for Councilor Koff. And I might call on Member Daly to add some support to this. But my understanding is, while Councilor Koff, you did talk about how attorney's fees cannot be required by an association when it comes to the foreclosure, so you can pay the principal. It's my understanding that 515A, the Condominium Act, doesn't have that same exemption. So there's some associations that can and Ms. Daly, my understanding is that you worked in a particular scenario in which an association's attorney represented that. Is that correct?
Yeah, that's correct.
Daly.
I'm going, oh, sorry if I'm chair. Do you mind if I address that?
Ms. Daly.
Yeah, I do have an ongoing case where I'm being told by the attorney that this new law does not apply because it's a townhome.
Okay, so that's different.
Pre-1994.
So I just want to clarify the law here, which is that 515A no longer applies to condominiums at all. All condominiums in Minnesota are bound by 515B. However, Ms. Daly is correct, which is that townhomes, so a planned community, as opposed to a condominium that was created prior to the law's adoption in June of 1994, are not bound by CICHOA unless they opt in. Ms. Howard, tell me if you agree. I would say upwards of 80% of older townhomes have opted in, but there is still a little team of townhomes that have not opted into CICHOA and thus are only bound by their documents and then 317A.
All right. Yes, Ms. Howard, if you want to briefly answer, and then we're going to move on.
Oh, thank you, Madam Chair. Yes, I don't know what the numbers are, but I mean, I've got probably 8 or 10 projects going at this very moment where we are redoing documents to opt those associations in, whether they're the older townhome associations that were formed prior to 1994, or we talked at another session, the really old condominiums that are formed under Chapter 515, which are largely but not completely governed under 515B. So we are doing a lot of opt-ins for them as well.
All right. Thank you, Ms. Howard. With that, I want to thank Councilor Kauf for attending. I appreciate the robust discussion from members and from their speakers. Thank you for that. And we are going to move on to the next section of our agenda. Briefly, I do understand that we are at 3 minutes to our cutoff time, and I want to be respectful that there are members that may need to go if you have to pick up kiddos or have other obligations. So I just want to be clear that we may have some folks dropping off shortly here. With that, I do want to go into the next part of the recommendation, which is to talk through some recommendations coming out of today's. And Ms. Pollock, did you want me to do that, or did you want to bring up the document and record any
No,
recommendations?
Madam Chair, I have it up and I'm happy to record.
Perfect. All right. Thank you. So then let's go through, and any members that heard out of today's conversation, potential recommendations that have to do with dispute resolution, that they would like to bring forward. I think one of the obvious ones was probably the ombudsman. There seemed to be a lot of support for that. And I think we may have captured that already, but we certainly, I think that was an obvious one. Member Daly, did you have one that you wanted to bring forward?
Thank you, Chair. Yeah, actually, I was going to mention just what we were just talking about, which is that there is this small group of older townhomes that are not subject to the new law being the law that says a person does not have to pay attorney's fees in order to avoid the loss of their home. And that law, and what we were talking about earlier, is $50 fine. They can just pay the $56. They don't have to pay the $2,000 in attorney's fees to save their house. But that does not apply to townhomes that were created before 1994. So I would have a suggestion of this would not be an amendment to 515B, but it would be maybe in the foreclosure statute or put somewhere that new law applies to all common interest communities, regardless of whether they're a condo or a townhome or when they were created, so that people aren't losing their homes over these large attorney's fees.
So in a succinct fashion, we want to make sure that the new foreclosure laws apply to townhomes as well, including those that fall under statute that were built before 1994 and may not currently be part of 515B.
Exactly.
Did I get that right?
Yeah.
Okay. Trying to make it easy, but succinct. All right. Member Taylor, did you have a recommendation?
Yes, I have a few. New Jersey made their HOAs quasi-governmental for the purpose of open meeting law regulations. I think a lot of disputes happen because of that. We don't have a requirement for open meetings. I think there's some requirements around certain meetings having to be open. I don't think this applies to that operations piece where people talk in between to get things done. Really is about those open meetings. Our board was not having open working meetings and would just come and have board meetings where the decisions were made already. So I think that's an interesting regulation. I think New Jersey and another state ended up doing that. Another recommendation would be around rules. So
Before we
keep
go
saying we're
further,
opting.
Member
Oh, go
Taylor,
ahead.
I just want to make sure we captured that you're
Sure.
saying that Minnesota should consider
Yes.
changes to open meeting regulations similar to those in New Jersey.
Yes. So they had a task force on this in 1996, I believe it was, where a lot of the very same issues in 1996 are what we're still talking about in our task force. And they came up with a number of recommendations. And one of the things that did come out of it was changing kind of the structure or the classification of HOAs being required to operate in this quasi-governmental fashion for the purpose of open meetings and transparency and accountability. And I think that that's where some conflict happens. So it could help with that dispute before we even need to get to that dispute resolution process.
Okay. All right. And then you had an additional suggestion?
Yes. I'm sorry, when I'm interrupted, I lose my train of thought.
That's all right. Sorry.
It was about, that's just the way my brain works. It's fine. The second one was about, hold on, let me see if I took the little one out. Oh yeah. Okay. So, we're talking about how we're opting into living in these places, but we're also talking about how almost all new construction is being put into HOAs. So it's really not a matter of choice, especially as a first-time home buyer when these are the most affordable options. And so considering those things, one of the rules in manufactured housing is that the rules that you sign up for when you buy your manufactured home are your rules forever. There are reasonable changes allowed, but basically the rules in your lease when you sign up are your rules. So what happens now with HOAs, at least in the one that I'm in, is the board is allowed to change the rules whenever they want. Just the board. We don't have to have homeowner votes. We don't have to have anything like that. So, and I think that's in Minnesota law as well, that the board's allowed to create rules upon rules upon rules upon rules.
Okay.
And so I think that that is not an opting in to, when you buy into a place, you review the rules, you decide these rules work for me. But then as you go on, and whoever's on the board decides they want to impose more and more and more and more rules, whether you deem them reasonable or not, you haven't gotten to have a voice in the passage of those rules. So manufactured home law only allows reasonable rule changes. The Attorney General gets to enforce those reasonable rule changes. And I think a similar law would be helpful in this situation where manufactured homes have a property management since there's the land being owned. And this is a similar situation that I think having something like that, mirroring manufactured home law in that way, including the enforcement by the Attorney General about the reasonableness of rules, would be helpful to some of these dispute issues.
Okay. All right. Thank you for that. Member Murray.
Oh, thank you, Madam Chair. I would like us to consider a suggestion where we update the statute to explicitly state the purpose of HOAs is to create shared interest communities to facilitate the peaceable enjoyment of people in their homes through cooperation, common buying power, and common maintenance. So that we are stating it's not to create perfect, like, we aren't arguing about the trees or how things look. We are focused on people having peaceable enjoyment in their homes.
Okay,
The
so
second,
Member Murray, you said the enjoyment of people's homes and maintenance of shared, I'm sorry, I missed the second part of that.
shared buying power. Here,
It's
I will
shared
paste it
buying power.
for Andrew. Peaceable enjoyment of their homes through cooperation, common buying power of the community, and common maintenance.
And common maintenance. Okay. All right.
The goal is to facilitate communities. My second recommendation would be to make unenforced covenants automatically revoked unless HOAs collectively renew them at annual meetings. And that could be annually or like every couple of years. But if we have a rule we're not enforcing, we shouldn't leave this weapon of words laying there dormant to be selectively enforced.
So this is more not dispute resolution, but more about the dissolution, HOA dissolution, correct?
Not, I'm talking specifically about unenforced covenants. It could apply to the whole covenant, but I'm specifically saying if there's you cannot have you have to have an elm tree in your yard that's written into the covenant. That rule should go away after a year or 2 years or however many years it's lying dormant unenforced. If that rule isn't there, we can't have a fight about it. And that resolves the dispute by default.
Okay. All right. Thank you, Member Murray. Member Cole.
Thank you. I would love to see the ombudsman be a part of the mediation process and be able to have that meeting called by the homeowner with the association being required to show up and the association not be able to charge attorney's fees until the dispute is fully resolved. If the homeowner turns out to be the one that is wrong, okay, attorney's fees can be added, but attorney's fees can't be added as a disincentive for bringing the dispute to be resolved in the first place.
I think I heard two pieces there, if I'm being, just for clarification, that you were suggesting that there be something similar to what was discussed earlier by our friends at NCSL that California did. So that we should implement something similar to California that had sort of a written requirement that either party may put forward a sort of a request for a dispute resolutions. And that may be either the association or the homeowner. That's sort of part A. And then part B was that there should be limits on attorney fees while that issue is in resolution or is being resolved. Is that
right?
What your
And
suggestion is?
Yes, and the attorney's fees not be able to be added if the homeowner is found to be in the right on this. Yes, and for the ombudsman fees, if whoever requests that meeting, it should not be optional for the other person to show up. If the meeting is called, both places need to be there.
Okay. Okay. All right. Very
Thank
good.
you.
Thank you. And then Representative Meckland.
Thank you, Chair Bonner. Something that I've heard from multiple different homeowners associations, if a member simply has a question, whether there's something assessed or there's something that's been voted on or whatever, it's going to create some kind of fee, if they simply send either a written letter or an email simply asking questions, they are not aware that that's then going to get forwarded to an attorney, which then turns into an attorney bill, which they never asked for because they were simply asking questions. Is there any kind of protections against these hidden attorney fees that they didn't know were coming by simply asking for clarification?
So you're suggesting that a recommendation be that there are some parameters put in
Perhaps,
place around being able to ask, to reasonably ask questions without incurring attorney fees, so that there should be a process in place for asking questions without incurring.
Correct, Chair Bonner. If you
Attorney
recall,
fees.
I believe that we had a healthy floor debate on hidden fees, and when I started hearing about this, I was surprised to learn that if you simply send like a 3-4 questions in looking for clarification of what does this mean, or where did this information, how did this all come about, then it's then forwarded off to an attorney. Then all of a sudden you get an attorney bill. Then when you ask what's an itemized bill, or what can I get itemization what this bill's for, that incurs another bill. And I think we had somebody testify that 1 or 2 meetings ago, and I find it amazing. Like, I could understand if the homeowner had sought representation from an attorney, that would then automatically trigger a response from an attorney on the other side. However, if they're just simply a homeowner asking their HOA a simple question, that they then get blindsided by a bill. There's got to be some limitation within that regard, I would think.
And I think there was a earlier suggestion from one of the earlier sessions that under fees, that the attorneys be required to provide some transparency by providing a list of what those fees are or what they're being billed for. I'm saying it badly, but that there be some sort of accounting of what those fees are for, rather than simply a blank invoice. And I think that was recorded in an earlier item, but thank you for that one. Member Taylor.
Yes, thank you, Chair. A few other ones in terms of the some of the things that were brought up by speakers. I heard a suggestion that homeowners are also given timely notice of foreclosure and not just renters, if they're renting a unit. I think that's a very, very important one that I did not know wasn't happening. So I'm glad we were aware of that. For rule violations, I think it is reasonable that there are not fines that lead to foreclosure, but instead of loss of amenities, except for those related to like safety or maybe medical need to use those amenities, which can be provided for with notes, or garages or safety things like that. I think that's a more reasonable way to get folks into compliance. I think around what we were just discussing, the parameters around asking questions, I would like to know the clarification. We were told paying for property management gets access to their attorneys. So it's confusing to me why we would get charged for asking property management questions that get forwarded to their attorneys while also being charged property management fees for their services. So just kind of like agreeing that we need to address that. And then finally, I think that having a notice period sufficient enough for homeowners to seek foreclosure assistance programs, similar but much more robust than the pre-eviction notice requirement that was passed a couple sessions ago. So renters can access rental assistance programs, I think is super important. If people are not getting notice long enough to access and go through the process of receiving foreclosure assistance, and start to get the these fees accruing and interest accruing and things just snowballing. It really is a lack of all of our safety nets being able to work properly together. So making sure that we have things in law that allow for those things to work effectively gets everybody's needs met. HOA gets paid back, homeowners can get those things paid off as well.
So, Member Taylor, I just want to be clear. I think what you were saying is that there should be a reasonable window for homeowners to access
Yeah, and I think
foreclosure
if we could,
programs, not that it's an open.
correct. And I think if we could talk to foreclosure assistance programs, and these types of programs usually will tell you this is how long it takes for us to go through the process to get somebody foreclosure assistance, or to figure out if they qualify or what, and this is how long it takes to cut a check, those kind of things. And that can give you parameters around when that notice would be reasonable to access those types of things.
All right. Thank you, Member Taylor. Member Howard, you have a recommendation?
Thank you, Chair Bonner. More so a response to some of the other recommendations regarding the assessment of legal fees. I can tell you that 515B currently allows associations to assess back legal fees if they're incurred in connection with the collection of unpaid assessments, or the enforcement of the governing documents or the statutes. So currently, associations should not legally be or are not legally allowed to assess homeowners for simply asking questions and getting answers to them. So if associations are doing that, they are already in violation of the statute. So I don't think that's an issue with the statute. Again, I think it's an education issue that associations don't understand when they can or cannot assess back those fees.
Member Howard, I will say that I have heard repeated opportunities in which it is clear that associations are in fact doing that, which may be a violation of the law. But I also know that when homeowners have challenged associations, that what ends up ensuing is a long legal battle, even though they may not be following the law. Is there a reasonable recommendation or suggestion on how to improve upon that situation so that that boards are not in violation, or what remedy could there be for homeowners who are unfortunately incurring these costs in an unfair manner?
Certainly. Thank you, Chair Bonner. Yeah, I would suggest that if we're looking at making changes to the statute, that it would be a clarification of the existing language as to what does or does not constitute enforcement of the governing documents, because I think that's where the largest confusion comes, is, if somebody is, persistent in asking questions, and I tell my boards all the time, if they're just trying to request documentation and you have to reach out to me to ask if they're entitled to all of the things that they're asking for, that's not enforcement and you cannot charge them for that. So if there was some clarification that made it easily understandable to everybody, both the homeowners and the boards, as to when they can and cannot charge them back based on the existing parameters, but simply a clarification, I think that would be helpful.
I think in an earlier conversation, we talked about fees and, but I don't know if it was put into the recommendations, but that we should have a specific standardized lists that would give guidance to boards on which items were not eligible to assess a fee or a fine. For example, asking for a copy of a financial document, asking a question, those kinds of set. So I think what we might be suggesting here again is the recommendation that there be a standardized list that is clear and concise so that it makes it easier for boards to comply with the law. If that seems accurate.
Yeah, I think it would be cumbersome to try to create a list in the statute, just because you're always going to leave something out that then, okay, well, this isn't listed and so we can do it. So I'm not sure that a standardized list in the statute is the way to go, but yes, I agree that there needs to be clarification to all parties involved as to when fees can and cannot be assessed.
Well, I think the challenge is that what I hear a lot is that boards, even acting in good faith, do not feel that they have clear guidelines to understand when they can and cannot do so. And that the statute, for whatever reason, if it is perhaps just not written in a reasonable, user-friendly manner, have not been able to understand their roles and responsibilities fairly and accurately, and that may be leading to some of the disputes that we're seeing fairly commonly. So I think the suggestion might be that we have a very clear and transparent list for boards of when they may not assess those fines or fees. And I will double check with the law that was just passed. I have to review the language of that to make sure that we haven't already done so in that sense. But thank you for that. Member Murray.
Thank you, Madam Chair. I have a recommendation on that last one. I have one of the state websites for a partner law school like the University of Minnesota have a very clear wiki that is updated by the relevant ombudsman or authority. I don't know if this is owned by the Attorney General or whoever, for what is or is not billable. We just make it a couple people sign off by whatever oversight agencies and make it a simple process for suggesting changes or accessibility tweaks or whatever. My last recommendation is that we give, from the testimony we heard last night, I would like us to consider appropriating money for a housing advocacy center to pay interns or like people they find who have special interest in data to dig into and map the conflicts of interest we heard about from management companies and in the public meeting last night. It sounds like there are a bunch of connected issues that are to this resulting in these outcomes because people fight over money.
Yeah. And I do want to clarify too that if I remember correctly, when we had a conversation with NCSL earlier, that there are some states who do have a very specific conflict of interest document that relates to this specific issue, but that Minnesota is not one of the states who has implemented that. So it may be that we may also want to consider, Member Murray, reviewing what that law is that's been passed by a number of states. In fact, I think if I remember the map correctly, it was passed by a large number of states. It just has not been passed by Minnesota. And so it may be worth looking into that rather than reinventing the wheel.
Yep.
But we should probably recommend that we research adding the conflict of interest documentation that has been added by numerous states.
I'd recommend we add that as a separate item.
Okay.
Just for clarity.
Okay.
Because
got it. Okay.
Yep.
All right. So you're thinking more in addition to, not.
Yeah, I would certainly very much support that we adopt the conflict of interest standards. I was sort of horrified by our nonprofit law. I deal with a lot of national nonprofits and the fact that we do not, if you are in a relationship, you do not have to recuse yourself here if you're governing or like arbitrating a dispute.
Thank you, Member Murray. All right. And you may even have something to say about some of this, but Member Daly.
Thank you, Chair Bonner. I would like to reiterate that. I do think that some sort of conflict of interest regulations, standards for property management companies and boards and outside vendors, whatever, I think is important. I think we might want to think about some sort of licensure training of property management companies, maybe even boards, some sort of training for boards, standards of conduct that would apply to boards and management companies. I don't know enough about the contracts between the management companies and the associations. Chris Wilcox earlier talked about indemnification provisions in these contracts, which basically means that if the property management company does things wrong, it falls to the board to be responsible for that. So, they get sued, they turn around and the board pays them, which seems really kind of not what we want for a property management company who's taking on the role and the duty to carry out these somewhat complicated rules and regulations. And it seems to me that if there's some sort of liability going around, or if they took money they shouldn't take, they should be liable for that, not the board, because the board ultimately is all the owners and the property management company is there to serve the owners. So for them to not be responsible for any of their negligence or misdeeds seems a bit backwards to me. I think it might be I have a sort of a little laundry list here, so I don't know if we need, but
Go ahead.
Caps on fines, late fees. I think, sometimes I see these things where there's every single month, somebody falls behind, and now every month there's a late fee, but also some sort of monitoring fee. And so every single month that you're, even if you've missed like 2 months of payments because you're not fully caught up, every single month there's these new late fees and monitoring fees, and it just adds up to a point that seems a bit ridiculous. And then maybe a minimum amount to foreclose. I mean, it seems to me that if they're going to actually take somebody's home, it should be, this is a significant thing for the association. Like, this is a cost that the association can't bear, and so they really need to foreclose in order to be able to function as an association, versus we just don't like this thing that you did 6 months ago and you never paid the fine, and so now we're going to foreclose on you. That just seems unreasonable, especially given the high number of homes in these sorts of developments. It just creates this sort of overly policing of people in their own private homes. To me, the threat of losing your home is huge, and to be able to do it for minimal fines and fees seems.
Yes, and Member Daly, and I'm sorry, and feel free to throw it in the chat if I missed it, but I do recall that one of the members mentioned that there was a law, a state that had some sort of a regulation that they could not foreclose for amounts under $2,500. But I cannot.
That's right. To be honest, I don't have that at the top of my head. Who that is?
I do not recall.
Chair Bonner, that was Member Taylor. Yeah, I was saying that regulation was proposed and then it was lobbied against by CAI, even though it had bipartisan support, and was taken away and did not pass. But that regulation was proposed and had strong support in North Carolina. And
so it's proposed in North Carolina. Okay.
Yeah, proposed in North Carolina. And I can get you the bill number and drop that in the chat.
Okay, thank you for that. All right. And I'm sorry, Member Daly, I think you had another suggestion.
I think that was it, actually. I think I covered that basically. And I think Ron Elwood, who's, with Mid-Minnesota Legal Aid, he did some research on this different states in there. And I think he did come up with some states that do have that regulation in terms of a minimum amount to foreclose.
All right. Yes. All right. Thank you. We are out of time. we do want to give folks a chance to get on with their day. So I appreciate those folks who are able to stay a little later and kind of walk through some of these resolutions. We'll obviously need to clean up this language and make it a little bit more succinct. We may follow up with you if we have a question about your recommendation, or if there's clarifications as we move through some of that. But I appreciate your time today. With that, I'm going to call this session to a close. I do want to leave one last housekeeping and remind people that we have the next listening session has been confirmed for December 19th from 5:30 to 7:30 at the Ramsey County Library in Maplewood. That is at 3025 South Lawn Drive in Maplewood. Again, that is at December 19th, 5:30 to 7:30, Ramsey County Library at 3025 South Lawn Drive in Maplewood. Please note that I will be sending something out to members with a graphic so that they can post about that listening session and be able to share that with their contacts and with their circles. We finally got media to step it up and get us that. And then we also have our next meeting on Friday, December 20th from 10 to 12. That meeting will be hybrid, meaning some folks will be at the Capitol, but those who need to, for accommodations may attend by Zoom, excuse me. But I do encourage members to be in person for that meeting, and make sure that you are subscribed to the working group listserv found on the working group website to receive notifications about future meetings and opportunities to provide public testimony. And I believe staff, that is lcc.mn.gov/CICHOA/. Did I get that correct? Mr. George seems to be nodding.
Yes,
Okay.
generally correct. Yeah.
Again, for new members of the audience who may have missed it, that is lcc.mn.gov/CICHOA/. All right. Thank you. And with that, we are going to call this meeting adjourned. Thank you.